Sweeney, Patrick Sweeney.
We'll call the state of Wisconsin versus Patrick Sweeney. That's 21 CF 897, 21 CF 2035, 21 CF 2943, 22 CF 260. Appearances.
Always Khaleel appears for the state of Wisconsin.
Attorney Terrorize appears on behalf of Patrick Sweeney and as a friend of the court.
Your Honor, Attorney Nicholson appears as Marcy's law counsel on behalf of Alyssa Sweeney.
And Your Honor, I need a brief breakout room, please.
Okay, did you want to hear from the state and their position on bail and the victim's position before you speak with Mr. Sweeney?
No, I would like to speak to him first.
Okay, then we'll set that up just a second. I think I'm going to have to move you to breakout room 1. And now I think everybody can go to the breakout room.
Thank you, Your Honor. We are back.
All right, everybody's back. And Attorney Visser, did you get a copy of the criminal complaint?
I did a few minutes ago.
All right, and are you waiving a formal reading on behalf of Mr. Sweeney?
I am.
As far as a mailing address, what should we use?
The one that is on the complaint
right,
But again,
and-
it is not apartment 1, it is apartment 101.
Apartment 101, but everything else is correct.
Everything else is correct.
Okay, thank you. And Mr. Sweeney, assume you've been able to hear everything okay. If so, give me a thumbs up. If not, thumbs down. All right, he's provided a thumbs up. And this was a late ad. I'm partially through the criminal complaint. I'll continue to review that during the arguments. But there's certainly a probable cause for a count of stalking and several counts of felony bail jumping for purposes of addressing bond here today. And just checking my email to see if a public safety assessment was done in this particular case. And perhaps not, since it was a late ad. Mr. Matthews.
Your Honor, that's correct. There was not one completed in time.
All right, then I think before we hear from the state, we'll hear from Attorney Nicholson, Goetz, who's representing the victim, and you can weigh in on your thoughts on bond.
Thank you, Your Honor. I am here on behalf of Alyssa Sweeney, and I want to make a few things very clear. Number one, if you review the contents of this criminal complaint, at several points in Mr. Sweeney's writings, he suggests that Alyssa is somehow being manipulated to participate in prosecution against him or is otherwise an unwilling participant in this process. I wish to stress in absolute, obstreperous, unequivocal terms that Alyssa Sweeney wants absolutely nothing to do with this man. She does not want contact with him. She does not want emails from him. She doesn't want threatening letters from him at placement exchanges. She wants to be left alone. She doesn't want to participate in this process, but she has been forced to because of the unrepentant stalking that Mr. Sweeney has engaged in over the last several months. So I say that mostly for Mr. Sweeney's benefit because I am her counsel. I've spoken to her as recently as today. She does not want to speak to you again. I say that because clearly, as we're here with 60 plus charges, there has been this.
You're cutting out, Attorney.
To these.
Attorney Nicholson,
Sorry.
Goetz, you kind of cut out there, and I don't know that the court reporter caught that.
Sure. I wanted to say the second thing that I want to share is Alyssa has serious concerns for her safety, both based on the contents of everything that is before you today, but also because yesterday an order was entered in the family court suspending Mr. Sweeney's placement with his children. He has used the children repeatedly as a means and mechanism to justify spying on her, to justify following her, and to justify contacting her even above and beyond the bail conditions. I am extremely concerned that this restriction between him and the children will cause this behavior to escalate. I'm extremely concerned that he will become more threatening and more violent towards her because of the frustration with the children. So the timing of this, and I understand that he's going to be given bail. He has made his court appearances, and I am aware of that. In fact, I'm aware that he has repeatedly made voluntary police contact on his own. So this isn't a person who is fleeing as much as perhaps Miss Sweeney would like him to. This is a person who I know is present. That said, I don't believe in my career I've seen a more committed stalker. He's put in writing and acknowledged that he's been listening to the Alexa, that he is tracking with GPS monitoring my client's movements, that he has continued to persist and do so even after being arrested, not just once, but multiple times for both stalking and bail jumping. These bail conditions have been treated like an absolute joke. There is no hesitation for him to violate this no contact provision. There is no concern. He has produced written documents telling her, look, you have 24 hours to agree to dismiss these charges or bad things are going to happen to you, and I'm calling CPS. What she wants is for this to stop. She wants for it to stop. I am asking that the court take into account the utter failure to follow the conditions of bond. I don't know if the state is going to initiate forfeiture proceedings. If they do, I'd like to be heard on whether Miss Sweeney can recoup some of the forfeited bail because she has child care costs that are not being met because Mr. Sweeney's erratic behavior. is interrupting the ability to do that, and it's causing her family financial stress. She's had to take work off as a result of this. She's had to alter her behavior. He pulled a police officer over a few blocks from her home, which was outside of the GPS geographical restriction he's on, but he's still driving around there at all times. So I understand that you can't use cash as a mode to punish somebody, and I'm a defense attorney by trade. But I do think that when you have someone who has demonstrated over and over again to this extent that they are unable to follow basic rules of court procedure, that it's appropriate to make sure that the amount of bail that is set makes it clear that they must follow the rules or there will be significant consequences. And there are 2 counts that aren't felony bail jumping here. I'm asking that the court impose $5,000 per count on the stalking and the felony intimidation. And I'd like to see $1,000 per count on every bail jumping that's charged here. It's my understanding that Mr. Sweeney has access to almost $100,000. I've been in touch with his family, and they are concerned that anything that is 5 figures in bail, he's going to be able to post because there are still people that support him. And so I am asking the court to at least impose an amount of cash that when he inevitably violates this bail, probably tomorrow, because he's yet to make it 48 hours without contacting her, that at least then there would be some sting to it, because this has to stop.
All right, and I'm not seeing that any cash bail was posted, at least in any of the cases that we have on the calendar today, unless I'm misreading something.
That's correct, Your Honor. No cash bond has been ordered or posted.
Okay. Attorney Khaleel, your position on bail?
Thank you, Commissioner. In the case for which we are here today, the initial appearance, the state is asking that you order $150,000 cash bond. As far as non-monetary conditions, we ask that you order that Mr. Sweeney not consume or possess any alcohol, that he not be at any residence, place of employment, or other location where Alyssa, A-L-L-Y-S-A, last name, first initial S, is present, except only while at a staff law enforcement station for purposes of child exchange. That Mr. Sweeney not use or possess any controlled substances or drug paraphernalia without a valid prescription. That he not possess any dangerous weapons as defined under Wisconsin State Statute 939.22 subsection 10. And Mr. Sweeney not have any contact, direct or indirect, with Alyssa S. except only as necessary during child exchange or while attending family court proceedings. We also ask that you order that Mr. Sweeney not threaten or direct any acts of physical violence towards Alyssa S. We're also asking you, given the enormous record here, that you make a finding under Wisconsin State Statute 940.47. Your Honor, outside of a homicide case, I've never seen a case that demands 6-figure cash bond more than this one. I know we charged a lot of felony bail jumpings here, 66 counts of felony bail jumping. It may be hard for a lot of people to understand, but that number is a number reflective of restraint. I could have easily charged over 200 counts of felony bail jumping. And I assure everybody listening here today, if this goes to trial, I will prove 200 counts of felony bail jumping. And it will be the easiest trial with the greatest consequences I've ever dealt with. Ever. Mr. Sweeney is now charged with 3 separate counts of stalking the same woman over the last year, less than the last year. He's now charged with a total of 92 counts of felony bail jumping, Your Honor. Mr. Sweeney has repeatedly thumbed his nose at the orders of this court. He doesn't have missed court appearances because he's only been required to show up in person once. We don't have a great record of him showing up to court. He doesn't get and shouldn't get a ton of credit, especially in light of all of his other conduct here. So given the number of charges, the seriousness of charges, the number of charges that he will be found guilty of if this goes to trial, the strength of the state's case, which is entirely based off of electronic data, verifiable data. The defendant's total lack of compliance from minute by minute lack of of compliance with not just pretrial services, but with bail conditions. And again, the minimal track record of showing up to court, the likelihood, the very, very high likelihood. And it was kind of a modest or maybe, medium likelihood before this conduct, but now the very, very high likelihood, almost certainty that Mr. Sweeney will go to prison when convicted, and not if convicted, when convicted. And the fact that Mr. Sweeney has significant financial means. He is a known, very successful businessman in this community. There is publicly published information about how Mr. Sweeney has divested from a large business partnership that owns several restaurants in the area. Mr. Sweeney has access to funds that almost no one that comes before this court has access to. And so when we put someone who is indigent on $1,000 cash bond, that is the equivalent to putting someone like Mr. Sweeney on $100,000 cash bond. I think there is a moral imperative to put Mr. Sweeney on a six-figure cash bond here. But more importantly, because you're not here, going off of moral imperatives, there is a clear record here that demands six-figure cash bond, Commissioner. I'm asking you to please order a cash bond in that amount. In this case, I asked that you order $10K cash bond in the three other cases as well, for a total of $180,000 cash bond.
And are you asking that the conditions be modified to mirror the no contact requests in this case?
I think most of the cases, the no contact that I've asked for here does actually mirror the no contact in the other cases. There are a few additional conditions that I've listed out here.
Well, there's an exception that says he can have contact with her through our family wizard, and I guess I didn't hear you asking that.
Just to jump in on the the most recent one altered that to in-person contact for exchanges only. So only the two first cases have that our family wizard condition.
Right.
I would note that since placement is suspended, it's our position that an absolute no contact is fine. And if Mr. Sweeney regains placement, he can file a motion to ask for contact.
All right. And Attorney Visser, your position on bail.
Thank you. We are requesting a lower cash bail, something that he might be able to post. He has very limited access to any funds while in custody right now. While he may, as we would say when talking about other wealthy individuals, while he might be worth a substantial amount of money, much of that is not in a capacity that he can access it, especially since a lot of it is currently tied up and unavailable to him due to his divorce. So I would ask the court to not consider him as somebody who has endless six-figure resources. That's not his current reality. We would ask for something much lower, something in the four-figure range, not six-figure range, that he may possibly be able to post it. I'd like to point out that in my skimming through this complaint, not once does it allege physical harm or that he threatened her with physical harm, or that he threatened to, I don't believe he threatens to take the children from her or to remove anything, like not to like go to her house and take things or to do anything of that capacity. So to treat this like it's on par with a homicide, I think is not accurate. He is a longtime member of this community. He is not a flight risk. He is seeing a therapist weekly. He's already on pretrial services. We would ask that a much lower bond be posted, and we have no objection to the other conditions. Thank you.
All right, thank you. And Attorney Khaleel, if you wanted to respond, I'll allow that.
Your Honor, I'll just state that, it's hard to really ascertain what Mr. Sweeney's financial situation is. We're kind of, as it is for every situation, we're kind of making a guess based off of the available information. There certainly is information out there, certainly strongly suggesting that Mr. Sweeney is a man of significant financial means. I don't know for sure. I do think this conduct is very serious. I'm not saying the conduct is as serious as a homicide, but I'm saying the conduct, when taken together, is a risk of not showing up to court, fleeing, that is akin to being charged with a homicide because of the possible exposure that Mr. Sweeney is facing. I don't know. There are probably a half a dozen people in Dane County over the last couple of years who are facing as many individual felony charges as Mr. Sweeney is currently facing. You can probably count it on one hand. It is a significant amount, and I'm certain that each one of those people has received significant cash bond, and none of them, I'm sure, has the financial means that Mr. Sweeney has. So I'm asking, Your Honor, for the amount that the state requested, a total of $180,000 across these 4 cases.
Your Honor, if I could say a quick word.
Patrick, I would not
Well,
suggest
Mr.
that.
Sweeney, Attorney Visser is advising you not to, and I think that's probably pretty good advice because today's not the trial. There's a court reporter who's going to be taking everything down, and anything you say, even though you think it might be useful, could be used against you later on.
I understand that, but there's a lot at stake here, and there's something that I need to say, and if it's used against me, I understand that.
Well, if you need to speak with Attorney Visser in a breakout room, I can set that up. So you have an opportunity to talk to her, but her advice, as you've heard, is to not say anything on your own here.
Okay, yeah, let's do that quick then. Thank you.
Okay.
Just want to make sure that's still set up. Yeah, I think that's still set up. Everybody should be able to go to the breakout room.
It's not giving me the prompt.
I think you just need to hover down in the lower right. You're still listed as eligible to go to breakout room 1.
Oh, breakout room. I see. Thank you.
Sure.
Your Honor, just while there's the breakout room on, I would note that I'll say this again when Ms. Visser's back, because I'm sure she'll want to respond to it. But the Sweeney family attorney is watching this hearing on live stream and has just emailed me asking to let the court know that several Sweeney family members, Ann Sweeney, Mark Sweeney, and Colleen Sweeney, are requesting that Patrick be prohibited from contacting or threatening them via text message or email. So they're seeking no contact provisions as well. So I just received that information from another attorney.
We'll wait till Attorney Visser comes back.
Very good. Thank you.
Thank you, Your Honor. We are back.
Attorney Visser, while you were in the breakout room, I did receive an email that I made the court aware of from Attorney Dan Glinert, and he represents several members of the Sweeney family, Ann Sweeney, Mark Sweeney, and Colleen Sweeney. They are 3 family members who received some of the messages that were turned over after this investigation. Those
You're cutting in
messages
and out,
from
Attorney
my
Nicholson.
independent
Yes,
recollection.
Can you repeat that?
Sure. Those messages from my recollection were largely messages that talked about the relationship between he and Alyssa and was seeking some assistance or support from his family. They were aggressive in tone, and Attorney Glinert has asked me to alert the court that those 3 individuals would also like a no contact condition of bail. They're uncomfortable receiving messages of that nature from Mr. Sweeney. So I am not their attorney. Mr. Glinert is, but he and I have been in touch, and I said I'd relate.
There already is a no contact. You guys, there already is with those 3.
Mr.
Right.
Sweeney, again, you've been reminded you got the right to remain silent. Your attorney can speak for you and doesn't want you to make any statements.
I think they're still asking for that to be ordered on the newest case, though. So that's my only addition.
If I can clarify, is that you said his sister, or sorry.
Ann,
Alyssa's
Colleen,
sister-
and Mark. All last name Sweeney.
Okay, so those are not the individuals that are named in this complaint. I see initials on page 28.
I don't believe they're named victims in this complaint. I believe the named victim in this complaint is Alyssa. These are just people that received some of the messages.
Okay. Some of the messages in this complaint or other messages?
I believe other messages and copies of some of the messages in this complaint. Also he has made reference to refusing to comply with requests for no contact with his family before. And this is just the information I'm getting. I understand it's not a part of this charge defense, but I think it's the overall course of conduct here that we've got contact with people that are expressing they don't desire it. And so I think it's appropriate for me to at least ask. I know that Attorney Glinert has indicated they may pursue injunctive relief. That'll be a separate issue.
I'm going to go again. So in respectful response to that, I don't believe the court, and I don't know if the court has authority to order no contact with individuals who are not listed in this complaint and who are not considered victims, I think, of any of the allegations that are listed in any of his complaints. So that's my response on that. What Mr. Sweeney wanted me to convey to the court is to reiterate his utmost concern for the safety of his children and that they are his highest priority. He understands that he won't be able to have contact with them for a while right now, but he has family counsel now, which he hasn't had for a while. So he has somebody else in his corner to help speak up for him so that he doesn't have to speak up for himself, which will be within the court's orders. And he just wanted that reiterated to the court.
Right. And Attorney Khaleel, briefly, are any of those individuals referenced as a victim or referenced in any of the criminal complaints other than the paragraph, which I think is talking to the lawyer who makes a statement in the new criminal complaint? I lost the page that was on. I think that's page 42.
I bet those are those people.
I'm sorry, Commissioner, can you explain can you repeat your question? I was a little confused about your specific question.
Right. Can you point to a portion of any of the 4 criminal complaints where the 3 people listed by Attorney Nicholson Goetz are alleged to be victims or are referenced in the complaint. I did note that there, I think, is a reference to them on page 42, but that appears to be more that they learned through somebody else, not necessarily contact by the defendant with them, but through somebody else about some of the defendant's actions. But I'm not sure that that explicitly involved them.
That's correct, Your Honor. I don't doubt that they have potentially legally valid grounds for a TRO. I don't think that they, Mr. Sweeney's behavior towards them is connected enough to this case or these cases for the state to request those conditions, even though we certainly respect and understand why those individuals would like those conditions put in place here. That's why we're not requesting them.
I have to say something for myself.
No.
I have to, okay? There's significant evidence in this family case that a particular family member, my uncle Joe Sweeney, who's listed in this complaint, has conspired with Alyssa to dissuade the family courts. It's without a doubt. And so I've been trying to figure out this whole time how Joe got involved, even though he's completely unqualified. I know what his intention and his motive is, but this bleeds across all the cases, right? So when Joe Sweeney's involvement in the family case gave the GAL and this psychiatrist or psychologist the authority to make a recommendation, it was based off of absolute intentional collusion, I think the word is. And so I'm trying to find out the answer of how he was involved in this, became to be involved in this, and how is allowed. And as far as Alyssa Sweeney goes, I used to talk to my kids 3 times a day, and everybody was happy during divorce. And then a man moved into our house 5 months ago, and I haven't been able to talk to my kids since. Okay, I only get 5% placement with them. All I'm interested to know is, are my kids okay? How do I contact them? And if those things are settled, I'm okay with everything else. There's no stalking, there's no violence, nothing. I just want to know my kids are okay. And the pattern has changed so drastically that I have reason for concern. I have contacted CPS. I have contacted Fitchburg Police. I have contacted the Oregon Police. I have talked to Detective Mike Hansen in Madison. This is all I need to find out. I am happy to leave her alone. My personal life is as far away from her as it could be. I'm talking, seeing other people. I'm not interested in Alyssa, only my kids. And her behavior has been very concerning for me. That's all I have.
All right, thank you. Thank you to everyone for the arguments. So I'll take issue with Attorney Nicholson Goetz's statement or suggestion that I can only address appearance risk at this particular point in time, because there are statutes in Chapter 969 that allow for forfeiture of bail or an increase of bail simply because somebody has violated conditions of bond, even though they've made all of their court dates. So I think we're clearly in a different territory with respect to the 3 cases where we're here for return on warrant, and a grayer area with respect to the 22 CF 260 case. But there's clear statutory authority in the other 3 cases to take that into consideration. I wouldn't dispute that ultimately the largest factor ought to be appearance risk and not protection of the public. It's pretty clear that I don't have any authority to engage in preventative detention by denying Mr. Sweeney bail or setting an amount that's just simply designed that it can't be reached. I think given that Mr. Sweeney has continued to violate conditions of bail in the same manner and now is on his 4th case, he can't be trusted to appear in court. He's simply not interested in following court orders, or unwilling to, unable to, I'm not sure what it is. And each continuing case makes it that much more likely that Mr. Sweeney is going to get convicted, and much more likely that he would serve a prison sentence, and a potentially lengthy one. I don't think we're in the situation where we're talking about a homicide case as far as the realistic amount of time that we could expect Mr. Sweeney to spend in prison. So I guess I disagree with that contention somewhat. I disagree with the bail recommendations by all three counsel. I respect their abilities certainly, and respect the arguments that they've made here. I think Attorney Visser's suggestion of a bail in the $1,000 to $10,000 range is woefully insufficient to one, protect the public, because I think I get to consider that to a degree here because of the 3 cases where he's already out on bond. And I think it's insufficient to assure Mr. Sweeney's appearance here in court. This is always a difficult thing because I don't know somebody's finances. The state and Attorney Nicholson Goetz suggests Mr. Sweeney has hundreds of thousands of dollars available. Attorney Visser suggests that he doesn't have access to that. There's no magic formula for doing this, but this is what I think is appropriate and necessary. So with respect to the 3 return on warrant, or I guess it wasn't a return on warrant because it was actually set for bail hearings for a very specific purpose, to make sure that Mr. Sweeney would still be able to be on pretrial services if he were able to post bail and be released, because I think that's certainly important in light of the nature of the charges. I'm going to adopt the state's request in regards to $10,000 cash bail in each of those cases. Again, order all the prior non-monetary conditions. If any of those actually still allowed contact for purposes of our family wizard or any sort of contact, I'm going to modify those. I agree with Attorney Nicholson Goetz. If the family court has suspended Mr. Sweeney's ability to have placement, there's no need at this particular point in time for any sort of contact at a police department or court proceedings. That can get modified later. So I'm simply going to be ordering no contact, direct or indirect, with Alyssa S. in each of those 3 cases. And then I think the rest of the conditions that are set are not really inconsistent with what Attorney Khaleel has requested here today. But if I'm missing something, let me know. In the new case, I'm going to set $50,000 cash bail. I will order pretrial services again. If he posts in these cases, he needs to report immediately to pretrial services if they're open, if not no later than 10 a.m. on the business day following his release from jail. I will order that they equip him with a GPS and again, remote breath alcohol monitoring to assure compliance with the condition that he not possess any alcohol, that he not be at any residence or place where Alyssa S. is at, that he not use or possess controlled substances or drug paraphernalia without a valid prescription. I'll order that he not use or possess any dangerous weapons, as that term is defined by the state statutes. Again, to be consistent with the other cases where I'm modifying the bond, a strict no contact, direct or indirect, with Alyssa S. I'm not going to order the no contacts with the other individuals that were requested. I agree with Attorney Khaleel. I don't think there's a sufficient enough nexus, at least in the complaints that I've got here. And I did finish during the breakout sessions the newest complaint and get through that. I think there is some protection already in one of the other cases where it says that he's essentially not to solicit any other individuals to contact Alyssa S. or be at a location where she's at. So I think there's already some protection in regards to that there, and nothing prevents them from seeking a temporary restraining order if they believe that they have grounds for that. I will make the findings under section 940.47 based upon the intimidation count here, and quite frankly, the fact that there have been bond conditions with respect to the no contact except under certain limited circumstances. And Mr. Sweeney has continued to violate that. I think that just sends a chilling message to a victim, and it is intimidation. It's appropriate to order that no contact pursuant to that statute, because there's certainly substantial evidence of knowing malicious prevention or dissuasion of any victims or witnesses in this case. What that means, Mr. Sweeney, is regardless of whether you choose to sign a bond or able to post the bond, if you're having any contact, you could still be charged with a contempt and be subject to potential jail sanctions or punishment. I think the clerk asked about whether I'd ordered the no alcohol condition. I believe I had ordered that in this particular case. If I didn't, I certainly intended to. I know that was asked by the state. As far as time limits for a preliminary hearing, Attorney Visser, I assume you'd like a timely preliminary hearing, 22 CF 260.
I believe so. To be clear, and I should have clarified this earlier, I have not yet been retained on this case or the one immediately preceding it. I will be going to visit Patrick later. I do anticipate being retained. So speaking as a friend of the court and having spoken with Patrick earlier, I believe that he does intend to enforce the time limits on this prelim. And I
All
would
right,
ask
Mr. Sweeney,
that-
is that correct? You'd like
Yes.
a preliminary
Yes,
hearing
Your Honor.
within 10 days?
Yes, Your Honor.
Okay. Then if there's nothing further, we'll be adjourned. Thank you.
Thank you.
She needs to tell the truth.
Next is Mr. Nelson, Gary Nelson.